Imagine your boss walks up to you, holds out their hand, and says, "Give me your personal cell phone and your passcode, right now, or you're fired." Not your work phone, your personal phone, the one with your medical records, your private conversations, your most intimate messages. And they're not asking, they're demanding. And HR is backing them up. That is exactly what happened to one California employee, and what they didn't know in that moment could have cost them everything. Let's talk about what the law actually says, because this situation is far more legally explosive than most people realize. To understand why this story matters, you need to understand the setting. California is, in many respects, the most employee-protective and privacy-protective state in the entire country. It has laws that go far beyond federal minimums in almost every area: worker rights, consumer data, medical privacy, and whistleblower protections. So when a company operating in California decides to launch what they're calling an internal investigation by demanding employees surrender their personal phones and passcodes, they are not operating in a legal vacuum. They are operating inside one of the most regulated environments on Earth. And they either don't know that, or they're hoping their employees don't. The employee at the center of this story works for a company that recently received an anonymous safety complaint, what's sometimes called a whistleblower report. Management, apparently panicked by the idea that someone on the inside had gone to regulators or authorities, decided the best course of action was to launch a dragnet. And by dragnet, I mean they called in every single employee and told them to hand over their personal cell phones along with the passcode to unlock them, so management could search through private messages looking for whoever filed the report. HR reinforced the demand by invoking California's at-will employment status, telling employees that refusing to cooperate with a company investigation was grounds for immediate termination. The employee telling this story had never used their personal phone for work purposes. There was no bring-your-own-device policy at this company. No agreement, no contract, nothing. And sitting on that phone was private medical information, the kind of deeply personal data nobody wants their employer anywhere near. So this person was facing what felt like an impossible choice: hand over everything private about their life, or lose their job and their health insurance. Here's where the story gets legally fascinating, and I want to walk through this carefully because there are multiple layers of protection stacking on top of each other here, and each one is important. Let's start with the California Constitution. Unlike the federal Constitution, which primarily protects individuals from government overreach, the California Constitution explicitly guarantees the right to privacy as an inalienable right. And California courts have interpreted this to apply between private parties, including employers and employees. That means an employer in California can face legal liability for invading an employee's privacy even when the government isn't involved. This isn't a gray area. This is foundational California law. Now layer on top of that the California Invasion of Privacy Act, sometimes called CIPA. This law places strict restrictions on unauthorized access to private communications. Forcing someone to hand over their phone passcode so you can read through their messages potentially implicates this statute in ways that should make any employer's attorney deeply uncomfortable. Then there's the California Consumer Privacy Act, the CCPA, which gives individuals strong rights over their personal data. A personal cell phone is essentially a vault of personal data. Location history, health app data, photos, messages, contacts. An employer conducting an unauthorized search of that device is touching data that carries serious legal implications under this framework. But here's the part that the HR department either didn't know or was deliberately trying to obscure. California has some of the strongest whistleblower protection laws in the country. Under California Labor Code, Section 1102.5, it is illegal for an employer to retaliate against an employee who has reported, or who the employer suspects of reporting, a violation of law to a government agency. And critically, the law protects not just people who actually filed a report, but people who are suspected of filing one. What this company was doing by launching a witch hunt to identify the whistleblower was potentially itself a violation of this statute. Every single employee being threatened and searched was potentially a victim of retaliation based on suspicion. This is a major turning point in the story because it flips the entire power dynamic. The company was presenting this as you must cooperate or face the consequences. But the legal reality was that the company itself was potentially committing violations with every demand it made. There's more. The National Labor Relations Act, federal law, protects employees' rights to engage in concerted activity, which can include discussing workplace safety concerns. Filing a safety complaint with OSHA or a similar agency is protected activity. California's own occupational safety and health laws include additional whistleblower protections. Trying to identify and presumably punish the person who filed that safety report doesn't just expose the company to privacy claims, it potentially exposes them to federal and state retaliation liability. And then there's the medical privacy angle, which this employee was rightly terrified about. California's Confidentiality of Medical Information Act, known as CMIA, prohibits employers from accessing employees' medical information without authorization. If an employer scrolled through someone's personal phone and encountered medical records, health app data, communications with a doctor, or insurance information, they would potentially be violating this law. The employee didn't need to prove the employer was specifically looking for medical information. The exposure alone creates liability. So let's recap what the company was actually doing. They were threatening employees who they suspected of engaging in legally protected whistleblower activity, demanding access to private personal property with no legal basis, potentially violating the California Constitution's privacy guarantee, potentially violating CCPA, touching on CCPA-protected personal data, and creating exposure under both state and federal retaliation statutes. And they dressed all of this up as a routine company investigation and told everyone HR said it was fine because California is at will. At-will employment means an employer can fire you for almost any reason or no reason, but it does not mean an employer can fire you for an illegal reason. Terminating an employee for refusing to waive their constitutional privacy rights or for refusing to assist in identifying a protected whistleblower is not a legal termination. It is a wrongful termination. The at-will card HR played was either ignorant or deliberately deceptive. Now let's talk about what you should actually do if you find yourself in this situation. First, do not hand over your phone. You are not legally required to give your personal device to your employer. Full stop. The demand itself is likely unlawful. Complying may not protect you anyway, and it definitely surrenders your leverage. Second, document everything immediately. Write down the date, time, what was said, who said it, who else was in the room. Save any written communications, emails, texts from work channels, anything in writing. This documentation is the foundation of any future legal claim. Third, say as little as possible to management and HR beyond "I need to consult with an attorney" before responding. Do not argue, do not explain, do not volunteer information. You have the right to seek legal counsel before complying with any demand that may affect your legal rights, and exercising that right is not insubordination. Fourth, contact an employment attorney immediately. In California, many employment attorneys work on contingency for wrongful termination and retaliation cases, meaning they don't get paid unless you win. You may be able to get a free consultation and understand your options without spending a dime up front. The California Labor Commissioner's Office also accepts retaliation complaints at no cost to you. Fifth, if the original safety complaint was legitimate, consider filing a formal complaint with Cal OSHA or the relevant regulatory body yourself, or cooperating with any existing investigation. Formal protection as a whistleblower strengthens your legal position significantly. Sixth, if you are terminated for refusing, that termination may constitute wrongful termination in violation of public policy, one of the exceptions to at-will employment in California. This is a viable civil lawsuit, and given the number of violations potentially at play here, it is one where damages could be significant. The broader lesson in this story is one that applies to a lot of workplace situations. Employers sometimes make demands that sound authoritative but have no legal foundation. They rely on employees not knowing their rights. The phrase "California is at will" gets weaponized constantly to make employees feel powerless. But at will is not a magic override for every protection the law provides. California workers have constitutional privacy rights. They have anti-retaliation protections. They have medical privacy rights. Those don't disappear because HR says something confidently in a conference room. Your employer may have more power than you in many ways, but they do not have the legal right to reach into your personal life, your personal property, and your private medical information just because they're panicking about a whistleblower report they don't like. If this happened to you, if your employer has ever demanded access to your personal device, threatened you for reporting safety violations, or used at-will employment as a cudgel to silence you, talk to an employment attorney in your state before you do anything else. The law may be more on your side than you think. And if you want to keep learning about real workplace legal situations, real rights, and what you can actually do when your employer crosses a line, subscribe. These stories are real, the laws are real, and knowing them might be the most important thing you ever do for yourself professionally.